Hi, I'm Steve Worrall. I've just posted a blog post on my GeorgiaEstatePlan.com website, and I just wanted to talk a little bit more about it, flesh it out a little bit. The title is, When is an Inheritance Not a Good Thing? So you'd think that an inheritance, apart from the loss of the loved one, of course, would be a good thing. In fact, I remember playing Monopoly as a kid, and I think there was a community chest card that had Mr. Monopoly being told that he'd inherited $100, and hands were coming out of the sides of the card saying, buy a Rolls Royce, buy a yacht, take a tour. And so sometimes it can be a good thing. It's a good use of money at an unexpected time. But there are times when a person may receive an inheritance that are not good things. Let's say you have a spouse or another beneficiary in a nursing home, or disabled some other way. Let's say your spouse is in a nursing home because of Parkinson's disease. They're on Medicaid. They have spent down their assets because with Medicaid you have to be both sick and broke. So let's say you've got someone that's a beneficiary that's spent down their assets to get qualified for Medicaid, and now all of a sudden they're receiving an inheritance from you. What is that going to do? Well, Medicaid is a needs-based program. You basically, as I said, have to be sick and broke. These are means-tested programs, which mean you have to own practically nothing to receive them. And so if they receive an inheritance from you, it will kick them off of that government program, and then they will have to spend every dime of that inheritance down to virtually nothing, and then can reapply for Medicaid again. It's best in these situations instead to make sure that when your spouse or other beneficiary receives an asset, that there is a contingent special needs trust provision in your estate plan. Now, with regard to a spouse, there is a specific Medicaid rule that says that a spouse's special needs trust provisions have to be in a will for them not to be disqualified from Medicaid. So in that case, you would create a special needs trust in a will. Now, you may otherwise have a living trust. You may have created that living trust for the purpose of avoiding probate. So it's somewhat counterintuitive here, but these are the Medicaid rules, and we have to follow them. Otherwise, our loved ones may get kicked off of these benefits. So with a will, the Medicaid rules do require that, and it would be a little bit more simplified process the probate would have to go through, because we're really only dealing with this part of the estate. Anything else that's going to a beneficiary that's not disabled would not have to go through this process. Now, if obviously we can't have a crystal ball and know that our beneficiaries at some point in the future might not be on a government benefit. So in that case, we include contingent special needs provisions in our trusts and our wills, so that when our loved ones receive the money from us, if they are in fact on a program because of their disability, that they will not be disqualified from them, and the benefits will instead be sent over to a trustee who will manage those benefits and use it to spend for the extras that person needs. So let's say that they either enhancing their home, transportation, entertainment, things like that the government benefits do not provide for. So this is something that we can help you with if you've got a beneficiary that is disabled now, or you're worried that at some point in the future that there might be a disabled beneficiary that you want to provide for. We can help you do it in the right way. Give us a call at Georgia Estate Plan at 770-425-6060. I'm Steve Worrall. We'll talk to you next time. Thanks.